Hi, everyone. My name is Cesar Rodriguez Garavito. I'm the co-director of the Center for Human Rights and Global Justice here at the NYU School of Law, and the director of the Climate Litigation Accelerator, which is the program that hosts this webinar series, which we put together for a global community of practice of litigants, researchers, scholars, practitioners, who are interested in looking at the intersection of human rights and climate action. If you're interested in watching recordings of past events, you can go to the Center for Human Rights and Global Justice's website. We host, that's where we upload all the recordings, and also soon the database of human rights and climate change lawsuits, which we have been updating for a year now. And I mentioned that because it's a very good segue into today's conversation, in that out of the almost 90 cases that have been filed anywhere in the world before national and international judicial or quasi-judicial bodies, this recent ruling by the German Constitutional Court from only a couple of weeks ago is probably the most consequential. And I say that having read most of those rulings and having read all the submissions in those cases, because of several reasons that I'm not going to anticipate here, because we have a fantastic panel that combines the expertise of the plaintiffs and those who were the key actors in bringing this case to the attention of the German Constitutional Court, and also prominent scholars, commentators of the German Constitutional Court's work from a comparative perspective. So I will only say that in reading the Constitutional Court's ruling, some ideas and questions that had been left unsettled in previous important rulings, including the well-known ruling of the Dutch Supreme Court in the Urgenda case in 2019, I think were addressed very cogently and powerfully by one of the constitutional tribunals that with the highest standing in comparative law. So because of the combination of the quality and concreteness of the arguments put forth by the Constitutional Court, and the fact that the German Constitutional Court already has considerable influence on other tribunals' jurisprudence, this combination will probably be quite influential in climate change and human rights jurisprudence going forward. We will have time to hopefully comment on a range of issues, everything from the way that the court treats the rights of future generations to the fact that it is a very time-sensitive jurisprudence that takes the timing, the non-linear timing of climate change into account, to the fact that it helps move the needle on key procedural issues like standing for suing governments on climate harms. And finally, it very helpfully articulates the complementarity between climate litigation at the domestic level and international negotiations among states at a time when, of course, we're moving towards hopefully a more aggressive and more decisive agreement in the Glasgow COP's Conference of the Parties later this year. So to discuss those and other important insights from the court's ruling, we have, as I said, an ideal panel. We have Lisa Goldner, who's the climate and energy campaigner at Greenpeace Germany. We also have Professor Michaela Heilbronner, who's a professor of public law and human rights at the University of Gießen. And finally, Matthias Kuhn, who teaches here at NYU Law and is also a professor of global law and social science research center and Humboldt University. So in the spirit of CLX's webinars, we won't have a series of formal presentations, but rather we'll structure this as an interactive roundtable. We'll start with Lisa, and we'll give her 5 minutes to comment on the background to the ruling, how this strategy was forged, and from the plaintiff's point of view, what the key takeaways from this ruling are. Lisa, the floor is yours.
Yeah, thank you very much, Cesar. Thank you very much for the invitation. I'm very honored to be speaking here today on this panel. I'll be speaking from my perspective as a climate campaigner. I'm not a lawyer, but I think that's what I can bring to this panel to see what was our motivation behind filing this case and what implications we've seen, which are enormous in the past weeks. Germany is far from a climate leader, and it's for this reason that we've taken Chancellor Merkel and the German government to court. This is already the second climate litigation case that we filed. The first one we filed with the Berlin Administrative Court in 2018, together with 3 farming families. And even though this case was dismissed, we could build a very solid foundations for lawsuits seeking for climate protection from the German government. And that's why we decided to take the next step in February of last year, and we filed this constitutional complaint against the German Climate Protection Act that the German government had passed in 2019. The complainants are 9 young people from Germany, including Fridays for Future activist Luisa Neubauer. And this constitutional complaint was initiated and is supported by Greenpeace Germany and 2 other German NGOs, German Watch and Protect the Planet. And in our complaint, we argued that this Climate Protection Act is not in line with the Paris Agreement, and it's insufficient to protect the basic human rights of the plaintiffs now and in the future. We argued that by failing to draw a clear emissions reduction path to carbon zero, the young plaintiffs' basic human rights are violated. We said that obligations to cut emissions cannot be put off to the future. They cannot be put off at the expense of younger and future generations. And I can assure you, I'm really overwhelmed by this massive win, by this massive success for climate justice that we've achieved, and also by the huge political implications that we've seen in the past 3 weeks. We've seen an unprecedented turmoil in German climate politics. After only a week, Chancellor Merkel announced that she would raise the German climate targets. Within less than a week after the court ruling, she made that announcement. Last week, the German government agreed on a new Climate Protection Act, and this one will be expected to be adopted in Parliament already by the end of June. So it's an incredible speed, and incredible advancement in German climate politics that we've seen since, and also in the debate, in our public debate in Germany around climate protection. So my lessons learned as a campaigner are that first, climate litigation works. First, this success really builds on our first climate case that we filed. It builds on the many, many climate litigation cases around the world that have come before us. It shows that these kinds of landmark decisions really can turn an entire climate, the entire climate politics of a country around. It can change the public discourse on climate within the blink of an eye. We now speak completely different around the human rights implications of climate crisis. I mean, we speak about it now for the first time. We speak about the concept of freedom really differently in relation or in the context of climate politics. Another lessons learned that I have is that in the process of this pursuing this climate litigation case, really lies a huge potential to challenge entrenched power, to shift mindsets, to reframe this public debate, and also to accelerate people's agencies. This climate litigation fostered collaboration from the ground up. We were able to form very powerful new alliances between NGOs like Greenpeace on the one hand, with the climate movement, with courageous climate lawyers and climate litigation scholars, and also climate scientists. So I think this is really a great success of all the different actors in the climate justice movement. And to come to a closing of my short introduction statement, I think this gives us so much support for our struggle for climate justice worldwide in the courtrooms, but also on the streets for climate justice. And I'm very thankful for that.
Thank you, Lisa, and thanks for this is the more succinct distillation of a very complex strategy that I've heard. So thanks for keeping to time. We'll surely have a chance to come back to some of the additional details of the ruling and of the strategy. And of course, we'll open it up to questions from the audience at around 30 past the hour. I just wanted to, by way of a segue into Matthias' intervention, I wanted to stress the point that Lisa made about the interpretation of freedoms. And I'm hoping that I'm not preempting any comment by one of our discussants, but I wanted to just quote briefly from the court statement where it says that fundamental rights are intertemporal guarantees of freedom, in that by prompting the government of Germany to do much more about climate change. Now, the court sees itself as preventing the imposition of what it calls radical abstinence for future generations, in that, of course, if freedoms are not curtailed today, then more radical curtailments of freedoms will need to be imposed to avert climate catastrophe in the future. And that kind of libertarian twist, coupled with an intertemporal understanding of rights, is definitely a novelty in constitutional jurisprudence on climate and human rights. So Matthias, the floor is yours.
Yes, thank you very much for that. That was already a very important kind of clarification of what is doctrinally interesting about this judgment, even though, of course, from a German perspective, the intertemporal aspect is new, but what wasn't new is the idea that the negative rights to freedom also give rise to protective duties against the state. But Lisa rightly said that this is a decision that shows that climate litigation before national courts can work. And that should in some ways be a surprise, because there really are, when you think about climate change and litigation before national court, there are three kinds of core barriers one would normally think would make it difficult to succeed. And yet here we have a success. So let me say something briefly about these three barriers and how they were overcome doctrinally by the court. The first thing, of course, is that climate change is something that affects, it's a global phenomenon that affects everyone. And the causal contributions to those effects are, each country is responsible for something, but no country is responsible for any concrete effect that we actually see. So, so the question is then, how do you get to court before, say, Germany, criticizing what the German government does or doesn't do, if you're positioned somewhere else in the world? Say, for example, as in this case, certain plaintiffs were in Nepal and Bangladesh. So this is about the extraterritorial protection awarded by nationally guaranteed constitutional rights. And the court says pretty straightforwardly that these rights bind public authorities with regard to anyone in the world. So if anybody can claim that their rights have been violated, if they can plausibly show that their position is affected by something that the German government does or doesn't do, but should be doing. So the idea that that the extraterritoriality is a problem turns out not to be one. What exactly the obligations are towards those who are outside of the territory, that then the court takes a differentiated view. It's not the same thing as towards those who live within the jurisdiction. So the obligations are, the specific obligations that follow from rights are differentiated. and contextualize, and then we could talk about what exactly that means and what that actually gives plaintiffs. But nonetheless, that's an important conceptual basic point to have articulated as clearly as the court did here. The second point is, when in the end this is all about the effects of climate change, and you're litigating before a national court which deals with what a national government does or doesn't do, the problem is that even when we look at Germany, a relatively economically powerful, not particularly small or not that big a state, its contributions to overall its part of overall carbon emissions is roughly 2% of the global emissions, 2%. And so whatever Germany does, I mean, let's say Germany reduces it to zero magically within the shortest of all possible timeframes. You might say the impact what Germany does in and of itself is not going to make much of a difference globally. So how does a court deal with that? How is that relevant when it assesses the duties of the German government? And here are two core things that the court does, both of which are not obvious, and both of which I think are nonetheless very good ways of putting it, are very good ways of reading the Constitution, of doctrinally articulating it. And that is the following. First, the court says, yes, this is an affair that concerns everybody, and this can only be dealt with through our cooperation. But that doesn't mean that the German government isn't under a duty to do specific things. It means, first of all, that it is under a duty to cooperate with others to get this done as the best of its ability. So it's under a duty to engage others and to cooperate with them to come up with some kind of effective solution relating to climate change. It's constitutional duty to do that. That raises the question, for example, if a government decided to get out of the Paris agreements, whether such an act would be unconstitutional under the German constitution. So which won't happen in the next German elections, hopefully, but it were the case that a Trump-like character came about and wanted to do something like that, then arguably that would be unconstitutional under the established doctrine now of the Constitutional Court. And the second is that even if all of this depends on cooperation, and the German government does what it can do, but it fails. Let's say there are no binding standards. A Paris Agreement, let's say cooperation doesn't work that well. You can at least make the claim that these climate goals won't be achieved anyway. Then the response that the court gave is that's not an excuse for Germany not to at least do its part, because a country such as Germany doing its part creates the trust and the preconditions that make successful cooperation, more likely internationally. So the collective action problem is worked out by the court as establishing a certain kind of trust, to engage in a behavior that fosters trust. It's not an excuse to get off the hook constitutionally. And so that's a remarkable position to articulate as a constitutional court in this regard. Okay, and I think I'll stop with that for the moment.
Thank you, Matthias, and thanks for remarking on the national-international interface, which is of interest to everyone, I imagine, in this meeting, and those of us in the community of practice of CLX who are interested in seeing how domestic strategies can contribute to accelerating the international negotiations, so that there is complementarity and some sort of virtuous circle being promoted between those two phenomena. And when the agenda court in 2019 had already kind of articulated the fair share doctrine, which is exactly what you nicely explained, Matthias, but also, as Matthias mentioned, the German court went beyond the agenda court by saying, well, the thing is that it's not only necessary at the domestic level for every state to do its fair share, but actually that's the way in which the international system would need to operate, because it needs to be based in trust and reciprocity. reciprocity. And that's the only way, from a kind of game theoretical point of view, that you can get out of the collective action dilemma of everyone trying to basically do as little as possible and waiting for everyone else to pitch in. And that is from a legal and also from a conceptual point of view and moral justice point of view, a key argument that hadn't been made as clearly in international jurisprudence so far. So thanks for remarking on that, Matthias. Michaela,
Thanks, Cesar, and thanks for having me all. So I must admit, when I said yes to this, I was a little bit worried that I'd be the only one who would end up finding the decision wrong. I was quite skeptical of the decision when I looked at it at first, and I'm generally a person who tends to be a court skeptic. That said, now that I've read the decision and I've sort of tried to do my homework a little bit preparing for this, I don't actually think that anymore. And I've overcome my own court skepticism, at least to some degree. So what I think is going on here, and what I think is how we should be thinking about this decision, is that this is another case of a court that's ratifying some social change that has been taking place over time in Germany and elsewhere. So in some sense, similar to decisions like Obergefell holding a right to same-sex marriage to be there under the US Constitution and things like that. So in my mind, that's the best way of making sense of this. Why? Clearly what the court is doing is a new thing. Both Lisa and Matthias have emphasized that there's a number of questions, I think, involved. The question whether there is some kind of justiciable right at all, which the court says, yes, there is, which I think is an important and necessary step. And then the second question is, of course, how does the court go about this? And you've both been talking already a little bit about this, the way the court is constructing that, and that the court is constructing this differently than we've seen in other courts, agenda in particular. So the court is not adopting there's a duty to protect, and that duty has not been met with regard to some substantive rights, but rather the court is using this idea of intertemporal guarantees of freedom to sort of then scrutinize what the government is doing and finding it sort of unconstitutional, finding it faulty on that basis. With regard to that particular sort of argument the court is adopting here, I'm still not convinced, I must say. I would have, if I had been on the court, I would have done actually what the plaintiffs had asked in that particular case. And I think I would have tried to make Article 28, which is a directive principle in the German Constitution, holding that there's a duty to protect the environment. That is justiciable, the court says, but it doesn't give subjective rights. It doesn't give rights to individuals to enforce this in courts. And the court that's sort of what is behind sort of the origins of Article 20A. And on that basis, the court turns away from using Article 20A directly. And then given that it doesn't want to use Article 20A directly, it doesn't want to create a new right, for example, by reading 20A together with human dignity, as the court has been doing in other cases before, for example, when sort of creating a right to a social subsistence minimum, a right to welfare. The court doesn't go that way either. And the court then comes to this negative rights frame, which I think you've explained before, so I don't need to say too much about that anymore. But ultimately, I think this is interesting from a comparative perspective, insofar as this might be a way for courts that are more conservative and that are more skeptical towards positive rights litigation, positive rights adjudication. The only question is, do you sort of need the things that are in the German Constitution for that? In particular, do you need a clause such as Article 20A in order to adopt this kind of argument about the intertemporal guarantee of negative rights? My suspicion is that you probably do not need that. My suspicion is that a court could well be arguing that if the government has made statutory rules saying that we will aim for climate neutrality at some point, but it doesn't spell out enough details, like it was the case in the German with the German case where the legislation only went till 2030. that in those cases, there could well be an argument made that there needs to be more in order to sort of hold the government to its own objectives that it sets under sort of consistency framework. And I think the Irish courts and so on have been going in a similar direction. So from that perspective, I think the German ruling is probably useful. It may show that even when we are not sort of doing the things that are understood as judicial activism, positive rights, right? Positive rights are always associated, I think, more with judicial activism. So there is a way of making these things justiciable, but in a sort of more actually legally conservative manner. So, and I think that's potentially interesting from a comparative perspective. Whether the court is then entirely successful in the way it does that, I would have sort of wanted a more sort of procedural framing, ideally, more of a framing where the court says more in terms of not just that the parliament needs to get involved, but perhaps providing more in terms of that there needs to be an inclusive process, integrating different social groups and how we, manage the challenge of climate change together. But I think this is, to be fair, minor quibbles. But yeah, I think I'll leave it at that for now. And I'm sure there are questions later. Thanks.
Thank you, Michaela. And this is a good time for attendees to start writing their questions in the chat box while we go through a second round of discussion here, more rapid fire now. So very quickly, Lisa, one of the striking features of the ruling is that it addresses the question of standing, which is a stumbling block for many litigants around the world. So many cases before European courts and definitely US courts have failed because courts have considered that the plaintiffs do not have standing, right? They're not being disproportionately affected by climate change for them to be entitled to a day in court. That, for example, was the stumbling block in the senior citizens case against Switzerland, which is now going to the European Court of Human Rights. And yet the Constitutional Court of Germany said, well, we find that plaintiffs do have standing. So I wanted to ask you about that specific issue. It's procedural in nature, but it's been a major obstacle for the success of some other cases. And also if you could comment quickly, and again, this is going to be quick reactions for now, on the request that plaintiffs made to the court to mandate government to be more specific about intermediate goals, like meaning what needs to happen between now and 2030, and the court chose to focus on the period after 2030. But the key ask was that, the complaint was that the government's plan was not detailed enough in terms of what needed to happen when, and the court found that claim plausible in ways that no other court had stated or affirmed in such a kind of explicit way. So if you could comment on those two points from a campaigner / plaintiff point of view.
Yeah, the question of standing, yeah, we've noticed that would be a very tricky point. It was also a tricky point with our first climate case. That's why, I mean, maybe I have to emphasize that again, that the ruling refers to 4 constitutional complaints, actually. Like there were 4 constitutional complaints filed against the German climate politics, and they were responded to with 1 ruling. And in each of their complaints, we have a different set of plaintiffs. And we chose the way of quite a difficult and complicated way of finding plaintiffs who can already claim a direct violation of their basic human rights by the impacts of climate change. So we were actively looking for these and then found these 3 farming families, that's how I say it. And the young plaintiffs in this constitutional complaints are the children of these 3 families. Another plaintiff who was already a plaintiff in the EU, the People's Climate case against the European Union, And then Luisa Neubauer is an exception, our group of plaintiffs, because she cannot claim that direct violation of the human rights. But for example, we have one plaintiff called Lukas. He runs a farm in the east of Germany, and his farm is very directly impacted by drought and by heavy rainfall, which are the major impacts we see of the climate crisis in Germany. So he could show, and we argued, or we showed that in much detail in our complaint, like how the impacts of climate change impact on him. But I think that's also interesting, but that again, I can only say as a non-lawyer, that this question of standing wasn't as much of a barrier as we expected it to be, right? We thought we had to look for plaintiffs who can claim and substantially argue how they are already today experiencing the impacts of climate crisis and how it violates their basic human rights. And but as we see with the other plaintiff groups of the other constitutional complaints, that wasn't a big barrier here anymore. Then about the specific request to the court. So this Climate Protection Act, it only included a climate target for 2030. Germany also had targets that go beyond that, but they're not legally binding and they were not enshrined in this Climate Protection Act. And in our complaint, we argued with the carbon budget and with the CO2 budget. And I think for campaigners like me, it has been really crucial to bring this into the debate. It's not only about setting targets, but these targets have to be based on science. They have to be based on a CO2 budget, and based on the targets in the Paris Agreement, it's possible to define this amount of CO2 emissions that every country can still emit to limit global heating to below 2 degrees, and ideally to keep the 1.5 imperative. So we were arguing on the basis of this CO2 budget and said that the targets have to be in line with the budgets. They have to be defined based on this budget. And so what the court used these arguments, they also refer to different budgets that have been defined by different scientific institutions in Germany, but they don't define a budget themselves. But here again, I am showing how it shifted the discourse. Like now in the public debate and in the political debate on climate, for the first time, we argue based on this CO2 budget approach. And these new targets that the German government now said they did not include a carbon budget in their revised climate protection plan. But I think that future governments, and this is an election here in Germany, they will have, I think there is no way around, or at least from a political perspective, around basing your climate demands on the budget and like the measures political parties are proposing on a carbon budget. And I'm seeing that in some of the political parties in the past months, past weeks. It feels like it's been months, but it's only 3 weeks.
Thanks, Lisa. And that's a crucial issue that's been missed by many other courts in decisions of all kinds, some going to government, some going to the plaintiffs, because courts and law in general, legal theory hasn't come to terms with the nonlinear nature of climate change. So it's not, climate change is not like many other major policy challenges in that delays are very costly. So one of the things that the court said in this case is, well, and it kept going back to the issue that the details in the short term are crucial, because delaying action in the short term will mean major restrictions of future generations and young people's freedoms. And so this is kind of the time sensitivity aspect of this ruling. And this is a good segue to the follow-up question that I wanted to pose to Matthias, and from a more kind of comparative constitutional law perspective, and from the point of view of broader discussions about the role of courts. So by now, it is pretty well established that most courts are willing to review government's actions and even climate mitigation targets. Even courts that have found 4 states have said that they reserve the right to look at the targets over time to see if they continue to be in conformity with human rights and international agreements. Now, the Constitutional Court of Germany in this particular case went beyond that and framed this capability, this competence, and this duty of courts in terms of the kind of the preservation of long-term concerns as opposed to the short-term urgencies of the political cycle. I'll quote from my admittedly amateur Google Translate version of the ruling here, but the court says at some point that environmental protection is, according to Article 28 of the Basic Law of Germany, is made a matter for the Constitution because the democratic political process is organized on a shorter term basis via electoral periods. However, structurally, it runs the risk of reacting more sluggishly to ecological concerns that are to be pursued in the long term, and because the future generations that are particularly affected today do not have their own voice in the political decision-making process. So, Matthias, what do you make of this role of courts as kind of the guardians of long-term concerns relative to the short-term urgencies of the political cycle?
Well, in some ways, this is a classical argument that sounds a lot like John Hart-Ely representation reinforcement, just this time in an intertemporal dimension. So the idea that there are certain kinds of groups that are not appropriately heard in the democratic process, and therefore there's a certain pathology, a bias in the democratic process that can be corrected through court intervention. That's the classical idea. And here the claim is made with regard to the intertemporal dimension, the generations that are not yet perhaps able to articulate themselves or participate in the democratic process, but who will follow later, who then are, by the time they are there, can be confronted with a situation which was much worse, and when the decision was being reached, it didn't take into account their interests in an adequate way. When I read that argument, first of all, it sounds deeply familiar, and on the other hand, I immediately thought of a whole range of other contexts where one might use this type of an argument. So think about budgetary questions. We can easily imagine a court, a more conservative court perhaps, taking up this argument as an argument for austerity when it comes to spending money and going into debt. Saying that we don't want the future generations to be burdened by paying off the debt that this generation is now willing to incur by spending a great deal of money, etc. So normally, so this is new. It's new. The idea of interpreting the idea of representation reinforcement to include the intergenerational dimension. Is new, it's interesting, it's a product, it can be applied it's potentially applicable in a wide range of circumstances. What normally, what in an argument that would normally be invoked against this type of intertemporal use of this type of argument is to suggest that it may well be that there are costs that are being, but it ultimately this is about everybody will get old, everybody, people will continue to live, or they have their children in whom they have an interest, etc. So if it isn't a particular minority, if it's not only a particular part of the population, but a whole generation, then normally the way our interests are structured, so a counterargument could go, is one that would be inclined to take those interests into account in some way or another. But I don't know. I haven't thought this through. I thought it was an interesting argument. It's obvious that it can be applied also in other contexts. But with regard to the judicial function, what I found most interesting, and one of the most interesting features of this decision, is how the court engages with the incredible empirical complexities relating to climate change. And it has to, in some ways, to say anything meaningful and to come up with concrete norms and concrete instructions. And it does so by basically using internationally agreed upon political benchmarks and constitutionalizing them and saying, well, this is at least reasonable. And as such, we can understand this as a concretization of the highly abstract constitutional requirement to fight climate change. So what does fighting climate change actually require us to do? Well, what it requires us to do is to ensure that the climate, that it doesn't get warmer than 1.5 to 2 degrees above pre-industrial levels. That's now constitutionalized in Germany. And now comes the question, okay, but what does that mean for Germany's contribution? Highly contentious normative question, how to allocate. Let's say we know what the residual budget, all kind of carbon dioxide is. That, again, highly empirical, complex question. But, German Constitutional Court says, scientists have built their models there. They themselves are not too certain about those models. But let's take that for the time being. It's the best that we have as a way of calculating it. Then we have the total budget. Now the question is, how do we come from the total budget to Germany's budget? How do we calculate that? And difficult questions of justice written about by lots of philosophers and etc. And the court just says, well, our Sachverständigenrat, the certain kind of council of experts, determined that a per capita orientation. We're 81 million people in Germany, and we're just assuming everybody gets to emit equally. That's a fair way of thinking about it. And if we assume that that's the case, then what's the budget going to look like? So lots and lots of ways of reducing empirical and normative complexity by basically decisionist elements, whereas the court doesn't do the deciding. The court just decides to use determinations made by other actors. It builds on them, and basically thereby it sprinkles constitutional patina on them. It makes them constitutionally authoritative now. It kind of uses those numbers to build a constitutional argument. And the way the court does that, deals with complexity here, is both very interesting as a matter of judicial strategy. From a normative point of view, it raises a lot of issues that are, I'm not suggesting that the court should not have done it. I think there are all kinds of contexts in which the court is right to do this type of thing. But at the same time, there are dangers connected to that. It's kind of a way of pushing politics into an existing framework, which may well, by other political actors, they may think about things very differently and want to blow it up. And at that point, they can't. Because now things have become constitutionalized. So the problem of over-constitutionalization lurks in the background, and of juristocracy lurks in the background when you have this type of technique. But on the other hand, of course, there may be good reasons to do this in some contexts as well. And in this case, this may well be a case where the overall, all things considered, this is a good approach to move forward. So I don't want to be too critical here, but at the very least, as a general way of thinking about the function of the judiciary, there are parts of the opinion here which use techniques which have which you can reflect on critically and have a certain ambivalence.
Thanks, Matthias. And the connection between, or the domestication of international scientific consensus is definitely a key feature of some of the more interesting and compelling and influential court decisions in the climate and human rights space. One could see this ruling and other rulings as basically translating lofty pledges being made at the international level, coupled with recommendations from the IPCC and other authorities, translating that into domestic traction, giving teeth to those commitments. In that way, and this is the argument that some of us may make in a book coming up out of the Climate Litigation Accelerator later this year, those court rulings are minimalistic. But if you look to this, and this is a segue into the common question for Michaela, from the point of view of constitutional law, they are pretty maximalist in terms of doctrinal innovations that we will need to make sense of post hoc. So this is an exercise in the scholarly and practitioners community, justifying, debating, filling the blanks that the forward-looking doctrines of courts like the German court have put on the table through these type of rulings. And speaking of which, Michaela, last kind of round before we open it up to the questions from the audience. And by the way, we'll go until 10 o'clock New York time. So we'll use a full hour as opposed to 50 minutes like we usually do in these events, because there's so much here and so many questions already in the chat box. But I wanted to give Michaela a chance to react to specific statement in the ruling about the kind of the iterative nature of this jurisprudence and of the iterative nature of regulation on climate change. One thing that the court keeps saying throughout the text is that targets will need to be updated, actions will need to be updated in light of the evolution of both the impact of existing policies and of the potential worsening of the situation of global heating. And in this way, the court takes on what Groni, de Burca, and others would call it an experimentalist approach to jurisprudence, right? They say, well, we're saying this now, but we may well have to step in the future, revise our own jurisprudence, or at least the urgency of jurisprudence, as the impacts of climate change become more dire. From a court skeptic point of view, this sounds a bit, it may sound a bit too ambitious. So I wanted to give you a chance to comment on this, Michaela, on this, the court leaving the door open to coming back to the fray and update and even make more urgent their pleas and their prods to the government in the future.
Well, thanks, Cesar. That's actually the part I like in some ways, right? I mean, and I know Grania's experimentalist approach, and in my own work, I draw on the work of Simon and Sable, who've written on destabilization rights and broader ideas of experimentalism. So I think that's exactly the right thing for the courts to do. I think the courts, the most important thing is that we have something that's justiciable now, and the courts will be there to look at what the government is doing. And the government needs to sort of develop processes to adapt this to changing science. What I would have liked is sort of a bit more spelling out in terms of how this may have to happen in the future, sort of setting up standards, maybe whom does saying the government has to consult experts, maybe that's clear anyways. The government has to consult certain groups. So I think that sort of thing, I have a bit of a South African background, so a more sort of participatory perspective, engagement, if you want, with major groups who have a stake in this, environmental organizations, for example. That is exactly, I think, the direction, which is not quite there yet. The court is going a little bit in that direction, saying at least Parliament has to look at this. It can't just be a governmental decree. But that's I think the positive angle to it.
Thank you. That leaves us with enough time for questions from the audience. And the first batch of questions, I'm merging some questions into clusters here. So for Lisa, several of our colleagues in attendance are asking about the implications, political and policy implications of the ruling. So you already mentioned that in a bit about that in your comments, but the question here is, what else would you expect by way of reactions from the government and future governments? And also, do you anticipate this ruling having an impact on future litigation in Germany?
Yes, so the political implications, as I said in my opening statement, has been that only a week after the ruling, the German government announced that they would raise Germany's climate targets. So the 2030 target is moved up from a 55% reduction to a 65% reduction compared to 1990 levels. Then a new target for the year 2040 has been defined, an 88% reduction, and the date for carbon neutrality has been moved from 2050 to 2045. And this has been enclosed in a new climate protection law, which defines also yearly, like a yearly emission reduction target for every sector. Like it says very specifically in which sector, how many tons of CO2 have to be reduced in 1 year. So how do I see this development? As I said, the speed is overwhelming. Like I don't think that anyone in the climate scene, climate movement would have expected a raise of the climate targets in Germany in this year. I mean, there is a pressure to revise the climate targets anyways due to the increased European climate target. It has just come at a much earlier state than expected, which I think is due to the fact that we will have federal elections. The Constitutional Court set a deadline for the revision of the Climate Protection Act until the end of 2022. So I think the speed is really thanks to the fact that the government knew they would have to raise the targets, and the fact that there are elections and climate protection is very high on the political agenda. But I think we should judge these new targets based on the CO2 budget. And what we did our own calculation. We took the CO2 budget as it has been suggested by this science body that advises the German government that is following this per capita approach that Matthias mentioned. And we came to the conclusion that the CO2 budget that Germany still has left as of today, it will be used up by 91% already by the year 2030, even with these revised targets. And I think eating up 91% of the cake and leaving the rest to the younger generation, I'm not a judge at the Constitutional Court, but I would say that is not intergenerational justice to use up this carbon budget so quickly. Oh, and if I can, I was already coming to an end, but I mean, this debate and the government's response has only been in relation to targets. Yeah, and targets are really crucial, but they don't reduce any CO2 emissions yet. So we are not yet at a point where measures have been increased. And that is the next step that has to happen now. Like setting targets is one thing, setting sufficient measures and actually reducing carbon emission, that's even more important.
Thank you, Lisa. And we'll do a last round of reactions, quick reactions on a common thread through many questions here in the chat box, which is the right. It's about the rights of future generations. So, is there anything in what the court said in this ruling that struck you, Matthias and Michaela, as particularly compelling, new? Of course, the court has the benefit of having very explicit language in the Constitution of Germany. So Article 20A has kind of explicit language about the rights of future generations, opposed to what many other courts have in their constitutional text. But was there anything here with regards to the rights of future generations that you found new or a contribution of some sort of novelty from the point of view of constitutional law? And if time allows, there's a question, Lisa, maybe you can wrap up at with a quick comment on how you worked with young plaintiffs to, of course, take care of the precautions and that need to be taken when dealing with young plaintiffs, some of them minors. So Matthias, Michaela, floor is yours.
Yeah, let me interpret your question in a way that also answers or at least takes up a question that's come up again in various ways about how significant the fact is that in the German constitution there is actually a provision which says that the natural habitat of human beings has to be protected. So, and that's clearly interpreted by the court as requiring it of trying to stop or trying to mitigate climate change. Now, if that was not in the constitution, then it would have been plausible for a government to say, and it would be utterly unattractive in many other ways, but it would not arguably be unconstitutional for a government to say, we think this idea of stopping climate change is hopeless. We've had this debate since the 1990s, and we've enacted all kinds of things, we did all kinds of things, but the fact is, in every year, humanity has emitted more. It's not going to work. And our approach, therefore, is not to try even to do this, but to mitigate the consequences. we're going to protect the rights of our citizens by taking measures and doing what is possible to change the way, to protect our infrastructure, to protect property, to do the kind of things that one can do to mitigate the consequences of climate change. This, of course, in the United States is part of the debate. On the conservative side, that's a position that you often hear. And that's a way, you might say, that you can protect your citizens, and even future generations can be protected through these types of measures. That door is closed when you have a constitutional provision that says you have to protect the natural condition. So at the very least, it's easy to interpret such a clause, as the court has done, as closing that door. And so I do think that clause plays an important role in the overall architecture of the argument. And I wonder really whether even a court that would otherwise adopt the type of doctrinal structure and the understanding of rights, etc., as the court does, whether it would whether it could replicate, whether it could come to the same kinds of conclusions as the court did. So I haven't thought this through entirely, but my first stab at this is that the whole idea of intergenerational protection of individuals through preventing climate change, to do something to prevent it from happening, is tied to something relatively contingent in the German constitution.
Thanks, Matthias. Michaela?
Yeah, I mean, I think if Article 20A isn't there, then there's either the agenda route, ECHR, positive obligations, right? You all know that judgment better than I do, I'm sure. But if there is at least legislative framework, then I think an argument like the German argument might work. I mean, I've said this before, and maybe to sort of repeat myself a little bit here, what the court is doing is, even though it's not sort of clearly doing the same as in its welfare rights jurisprudence, the court is nevertheless stipulating a sort of consistency framework, right? It says that you have set something, you have set yourself a target of climate neutrality, and this is also the thing that 20A requires. But they use the fact that the government has sort of put forward litigation on this as a way of saying, and this is how 20I has been sort of concretized by the legislature. And from this follows that if you've committed yourself to that, then in the future, under your current framework, the future generations will have to bear huge sort of limitations of their freedoms, and that would be disproportionate in the framework as compared to current generations. So what we have playing here, and some of the German commentators have that is a logic of equality, right? It's equality between generations. The German court has sort of dealt with that in a couple of contexts previously. In tax law, for example, ideas of intergenerational fairness, justice have played a role before, but the idea that this is something you can litigate doctrinally in those sharp terms as it's been done here in this judgment, that's, I think, the new thing. And here, I think, if you had a sufficiently clear legislative statement that basically puts up these targets, then you might still be able to work with the kind of argument the German court is making here, would be my sense.
I'm afraid we're out of time, but we'll take the question on working with young plaintiffs to the segment with the community of practice members. So this is a good way to close for everyone. CLX hosts a community of practice that now has over 100 organizations and individuals, practitioners, researchers from around the world that comes together regularly, at least once a month. After the public event, we have a half-an-hour discussion on strategic issues and new issues in research and practice and climate change and human rights litigation. So for those of you who are already part of that group, you have the separate link to log on to that session, and we'll take the question on young plaintiffs' rights and the precautions and the care in working with them to that space. And for those of you who are not yet part of the community of practice, you're welcome to email us and tell us a little bit about your work, so that we can also include you in the list and send you invites to future community of practice meetings. And you can do that in the link or by emailing the address that was given in the invite to this event. Jackie Gallant, one of the CLX legal associates, will be answering your requests. Thanks, everyone. It was great to have this panel discuss a really timely decision in a timely manner. So since time is of the essence, we wanted to organize an event very quickly, and definitely having this fantastic panel with us was quite a treat. And of course, this conversation will continue both inside CLX and beyond. So thanks, everyone. Great day, afternoon, evening, depending where you are. Bye-bye.
Thank you.
Thanks. Bye.
Thank you. Goodbye.
Bye.